Greetings, everyone. Thank you for joining us for today's webinar, Halfway There, July 2025 Updates in Background Screening Compliance. My name is Danielle Olivier, Marketing Generalist here at AccuSource HR, and I will be your moderator today. I'd like to take this opportunity to introduce today's presenter, Jennifer Damon, Vice President of Compliance, In-House Counsel at AccuSource HR. Jennifer graduated from the University of Akron School of Law with a Doctor of Law degree and has over 15 years of experience in the background screening industry. She's an experienced compliance professional with knowledge from both the employer and consumer reporting agency sides. She has performed various roles in the industry, manages AccuSource HR's contract process, and acts as its in-house counsel. Jennifer is responsible for AccuSource HR's compliance department, including federal, state, and local legislation changes and PBSA accreditation. She also oversees the company's privacy program and contracting needs. I will now turn the presentation over to Jennifer.
Thank you so much, Danielle. Hi, everyone. Thank you for joining us today for our compliance webinar. Before we get started, keep in mind that you can send over any questions you have during the presentation. I will answer as many of them as possible during the Q&A period, or if we run out of time, I will follow up by email. So let's get started. The title of this webinar is Halfway There, and at this point in 2025, we're more than halfway over with the year. So let's review what's happened in background screening since our last compliance update in January. I'll be focusing on the topics listed on the slide here, but feel free to bring up any other compliance questions as you come up with them. Today's topics include fair chance legislation and related laws, salary transparency, privacy laws, marijuana and other drug screening updates. I'm also going to talk about some other interesting bonus topics because who doesn't love bonus compliance? I know I absolutely do. Does that make me a bit of a dork? Absolutely. We're going to wrap up by reviewing industry trends for the remainder of the year and into 2026, and also share some compliance best practices that you can integrate into your own screening programs. So for those who have not joined me before, first, I start with a quick legal disclaimer. Even though I am an attorney, this webinar is informational only. I highly, highly, highly recommend that you reach out to your own in-house counsel or outside counsel as you review your screening programs. So first topic is fair chance legislation, which will involve a number of topics in this area. For example, you may also hear some people refer to these types of laws as ban the box laws. You may also see articles about clean slate laws or expungement laws. They can differ depending on the type of specific law or trend, but the general goals tend to be the same. Provide a second chance, or at least a better chance, to get a job or other opportunity, keeping in mind our independent contractors or other parties that we work with. Take fair chance laws, for example. They may prohibit employers from asking about criminal history before a certain point in the hiring process. The goal of these is to allow those with criminal history to make it farther in the hiring process before criminal history is either discussed or exposed through a background check. More of these laws tend to require individualized assessments, requiring a balancing of the factors, in other words. Here, the employer must show that the specific criminal history justifies denying the employment or other opportunity, keeping our IC friends in mind, and they must show why, following the factors that are outlined in the law. And the laws are pretty good about showing what they have to balance. Some of the laws can be pretty in-depth, involving an interactive process if the individual would like to provide information. What's clear is that fair chance is here to stay and is becoming more intense, which we'll talk about a little bit further. If you're somehow not subject to one of these laws, you should become familiar, I recommend pretty quickly, because at some point you're likely going to be involved with one, especially if you expand your footprint into different states or cities. Let's get started in the city of Minneapolis, which recently amended its civil rights ordinance. The ordinance applies to applicants and employees who partially or wholly perform work or other occupations within Minneapolis. Under the ordinance, which is an anti-discrimination law, there's a list of protected characteristics. As of August 1st, so coming up really shortly, in a couple days really, a protected characteristic named justice impacted status will be added to that list. But what does this mean? Justice impacted status is the state of having a criminal record or history, including any arrest, charge, conviction, period of incarceration, or past or current probationary status. To break it down, those who have a criminal record or history will be deemed to have a protected characteristic in Minneapolis under the ordinance. Minnesota's Fair Chance law has similar requirements as others we have previously seen. Employers cannot base an employment decision on a justice impacted status unless that decision is reasonably based on, first, the relationship between the underlying criminal conduct and the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of the position. So, how does the employer make that determination? Well, by performing an individualized assessment and considering 6 factors, which the law provides. So, this slide lists the 6 factors here. So, when assessing those factors, they have to determine whether the underlying criminal conduct relates to that individual's ability, capacity, and fitness to perform the duties and discharge the responsibilities of the position. So first, they need to consider, was that person convicted? Next, look at the length of time since that offense or conviction occurred. Was it years ago or was it more recent? That makes a difference. Look at the nature and severity of the offense or offenses. Was it a misdemeanor, a felony? Was it violent? Was it something less serious? How old was the individual when he or she committed the crime? Were they young? Were they just turning 18? Were they in their 30s? Did he or she provide any evidence of rehabilitation? Finally, is there any unreasonable risk to property or the safety or welfare? Whether is it to specific individuals or to the public. Conducting the assessment by balancing these factors will help the employer come to a reasoned and supported decision. And make sure that it's documented, because if there is any claim against the employer, it's very important to make sure that that's documented to help prove your case. Under the ordinance, an employer cannot make an adverse employment decision on an arrest that did not result in a conviction, meaning a true arrest only. However, an employer can make an adverse decision on a pending criminal matter. Of course, they have to follow that assessment process, the balancing of factors that we just talked about. If an individual is aggrieved under the ordinance, he or she can file a complaint with the Minneapolis Commission on Civil Rights. The commission can order hiring, reinstatement, and back pay. Washington State already has a traditional ban-the-box law that is codified in its revised code. However, in April, it passed a more robust fair chance law that will go into effect in a little under a year on July 1st for employers with 15 or more employees. For everyone else, it's going to be effective on July 1st, 2027. Employers cannot inquire about criminal records until after making a conditional offer of employment. This includes asking the applicant directly through a background check or through other means. They also cannot implement policies that automatically or categorically exclude individuals with criminal records from employment. Additionally, this law prohibits employers from advertising in a way that would prevent those with criminal records from applying. So for example, your ads can't say no criminal background or no felons. The law also imposes a new notice requirement where certain disclosures must be made before a criminal background check is requested. which is a bit different than other Fair Chance Act laws. So I did want to point that out. So if an employer advises an applicant that a position will be subject to a post-offer criminal history background check, the employer must immediately make a written disclosure. I'll get into that in just a minute. It's also important to note that the employer must make the same written disclosures if the applicant voluntarily discloses information about their criminal history during a job interview. So the written disclosure itself must summarize certain portions of Washington state law information, and it must include a copy of the Attorney General's Fair Chance Act Guide. So that is available already on the Attorney General's website. So they did make that available, which definitely helps. HB 1747 outlines prohibitions to what an employer can consider when rejecting applicants. So an employer cannot reject an applicant for failing to disclose a criminal record prior to receiving a conditional job offer, cannot take adverse action based on an individual's arrest or juvenile conviction record. There is an exception, however, for an adult arrest where the individual is out on bail or released on their own personal recognizance pending trial. So that's pretty similar to some of the other Fair Chance Acts that we've seen. The amendment also specifies that employers can only take adverse action based on an adult conviction record if the employer has a legitimate business reason for doing so. Starting to sound a little bit familiar, correct? Legitimate business reason means, based on the information known to the employer at the time of the decision, the employer believes in good faith that the nature of the underlying criminal conduct will either negatively impact the individual's fitness or ability to perform the position, or harm or cause injury to people, property, business reputation, or business assets. All of this is starting to sound pretty familiar, right? But there's little nuances that make it kind of hard to comply with all these, but it's all pretty familiar. In considering taking adverse action, an employer must provide a written individualized assessment to show how the conviction relates to the role. Again, 6 factors to consider. First, the seriousness of the underlying conduct involved with the record. Also, the number and types of the convictions. Consider the amount of time that's passed, excluding periods of incarceration. Also important to take into consideration any verifiable information provided by the individual, good conduct, work experience, anything that's happened in the meantime to show that they have been rehabilitated. They should also consider specific duties and responsibilities of the position that they are seeking, and then also where and how the position is going to be performed. After the individualized assessment, if the employer decides that it wants to move forward with taking adverse action, they have to provide written notice to the individual, similar to the pre-adverse action notice under the Fair Credit Reporting Act. So under that first notice, they must identify the record or records that will potentially disqualify the individual. At that point, they need to hold the position open for at least 2 business days. Keep in mind, if you're going to be combining the Washington Fair Chance letter, the first notice, with the Fair Credit Reporting Act pre-adverse notice, FCRA requires at least 5 business days. That's the recommended waiting period. So keep in mind, if you're going to do that, even though Washington has 2 business days, FCRA requires 5 business days. So keep that in mind. Make sure you're following the relevant laws. Waiting period gives that person time to respond, dispute if there's anything inaccurate, incomplete. They can also provide information about good conduct, other supporting information. If the employer, after that waiting period, decides to take final adverse action, the final notice must include specifics about that decision, including documentation about reasoning, its individualized assessment, including the impact of the conviction on the position or business operations, its assessment of any information provided by the individual in response to the first notice. So in other words, they can't ignore any information provided. They need to respond to it. Keep in mind, we are still almost a year away from the initial effective date of July 2026. So we should be receiving some more guidance as to the requirements. And as we receive them, we'll absolutely keep you updated in future webinars. Kansas City, Missouri passed an amendment to Chapter 38 of the City Civil Rights Code. This amendment was passed on January 16th. It did add criminal history status as a protected class, specifically prohibiting discrimination in employment, housing, and public accommodations based solely on a person's criminal record. So how does this impact background screening in particular? This ordinance requires individualized assessments of an applicant's criminal background in the context of the job role. Like the other Fair Chance Acts that we've been talking about today, the assessment has to include consideration of factors such as recency, severity, and relevance. It definitely applies to hiring by the City of Kansas City itself, but it's ambiguous as to whether it applies to private employers and the city based on how it's written. If you do business or have employers or employees in Kansas City, you may want to consider a review by council to determine how best to approach it, because it is pretty ambiguous as to who exactly it applies to at this point. And I don't believe there's been further guidance by the city as to its applicability. Let's move on to our next update, which deals with pay transparency. This topic has evolved and become more important as additional jurisdictions enact laws requiring employers to disclose pay compensation. A lot of times we read about or hear about these laws, but it can help to understand the purpose behind them. The goal is to facilitate pay equity, to ensure that individuals are paid the same based on job position or title, no matter race, gender, or other protected characteristics. When compensation data is readily available, it's easier for various parties, such as employees and state and federal agencies, to identify and address pay disparities based on those protected characteristics. So this information's out there, but what does it actually mean in practice? Part of the analysis involves determining whether the individuals are performing substantially similar work. The review should also include whether there's permissible reasons for disparities. So for example, one person may have worked for the company for 10 years and another person for 1 year. So does one person earn more than the other based on merit? In order to ensure that employees and applicants have information to address possible pay disparities, pay transparency laws tend to require employers to disclose compensation information to the public or to employees to ensure that any disparities are addressed and pay is as equal as it can be, taking into consideration those reasons why pay may be unequal for legitimate reasons, as I discussed. New Jersey's SB 2310 went into effect on June 1st. If you're not already in compliance and it applies to your organization, please consider reviewing and coming into compliance as quickly as possible. It applies to employers with 10 or more employees. That does include job placement and referral agencies and other employment agencies. Employers must disclose the hourly wage or salary or range of hourly wage or salary. They must also provide a listing of benefits or other compensation programs that the employee would be eligible for within his or her first 12 months of employment. So for example, if an employee may not be eligible for 401k immediately, like there's a waiting period, they still would need to list that if it's 6 months after the fact. It applies to promotions, new jobs, and transfer opportunities, and it does include those advertised internally or externally. Covered employers must make reasonable efforts to announce promotion opportunities to its employees. Notable, there's no private right of action. The Commissioner of Labor and Workforce Development can enforce the law by seeking civil penalties. And as you can see, they can be quite expensive, ranging from $1,000 from first violation up to $10,000 for multiple violations. So important to come into compliance if you are not already, and it does apply to you. And I skipped forward. Very excited about pay transparency. Vermont passed its own pay transparency law, and that just went into effect on July 1st. It applies to employers with 5 or more employees, and it's to any job that's physically located in Vermont or a remote position that's predominantly performed work for an office or work location that's physically located in Vermont. It does not apply to a position that's physically located outside of Vermont and that performs work that's predominantly for an office or work locations outside of Vermont. Employers must disclose the compensation or range of compensation for the position and job ads. It can be a good faith compensation summary by employers. It does specify that an advertisement is any written notice for a specific job opening that's made available to potential applicants. For example, it's not a general announcement of job openings. It does apply to internal and external job openings, as well as promotion and transfer opportunities. If you have positions with tip wages or commissions, make sure to review the law closely because there are special requirements for these areas. Keep in mind, if there are violations of this law, the employer may be required to pay restitution of wages or benefits or other relief. This one also passed, so if you're not already compliant and it applies to you, please look into this right away. Washington State had an existing pay transparency law, but this was amended and also became effective as of July 1st. For the next 2 years through July 27, 2027, employers do have a grace period where they can fix job postings. Under this process, applicants must notify employers in writing of non-compliant job postings. Employers then have 5 business days to correct the postings and notify third-party platforms if they have them posted there. If the postings are corrected in time, the applicant cannot seek penalties or damages. This is huge because plaintiff's bar was going after employers for violations, and it was becoming quite expensive. So Washington State gave a grace period for corrections to be made, but that grace period will only last for about 2 years. Additionally, employers are not liable for job ads that are digitally replicated and published without their permission. Damages were also clarified and now range from $100 to $5,000. It was also updated where courts are now directed to consider several factors when determining awards, including the size of the employer, whether the violation was willful, and the nature of the infraction. So it's definitely helpful that that legislators and courts are now taking into consideration and helping out and giving grace periods to come into compliance, and definitely helpful for employers. Massachusetts, new salary transparency law signed into law in 2024 becomes effective as of tomorrow. Law has 2 goals. The first, to increase wage transparency and to also close the gender-based wage gap in Massachusetts. So there is wage reporting that's required. The U.S. Equal Employment Opportunity Commission, or EEC, collects various types of data from employers who have at least 100 employees. Some of the reporting looks at job categories and demographic data. such as sex and race and ethnicity. Ultimately, the EEOC makes this data available to the public. Under this new law, Massachusetts wants to compile the same data, requiring Massachusetts employers, also with 100 or more employees, to provide the same reports to the Secretary of the Commonwealth, which will also then be published. The second goal of the law is to address pay transparency in job postings. It applies to private employers with at least 25 employees. They must post the pay range for a particular position on all job postings. It also applies to employees who are offered a promotion or transfer to a new position with different job responsibilities. Additionally, employers must provide pay range to an employee or applicant upon request. It's helpful to note that the pay range is defined as the annual salary range or hourly wage range that the covered employer reasonably and in good faith expects to pay for such a position at the time of posting. There is no private right of action. The Attorney General can bring fines, and it could be pretty hefty, up to $25,000, depending on the circumstances. We are going up to my area right now. Cleveland, Ohio recently passed a pay transparency law. It applies to all employers located within the city and also to the city of Cleveland itself. It does not include any local, state, or federal government. They must provide the pay range for all jobs and notifications, ads, and formal postings. In addition to wage, salary, and disclosure requirements, it also has salary history limitations. So employers in the city of Cleveland cannot ask about salary history or screen applicants based on current or prior salary history, including using it to meet minimum or maximum criteria. They also cannot rely solely on salary history when deciding whether or not to offer employment or determining how to set salary. They also cannot retaliate against or refuse to hire an applicant for choosing not to provide this information. There's some exceptions to the requirements and prohibitions. If there's laws, for example, that specifically require this information, they can be asked. If they are seeking a promotion or an internal transfer, of course, that employer or the city is already going to have that information. The applicant can voluntarily provide it. They can obtain that information from an employment verification. Typically that's provided and they're receiving it without asking for it. And yeah, the last exceptions related to applicants who are rehired. They can already have that past information. So if they're rehired, they already have that information. So that would be an exception because that information is already known. So they wouldn't be penalized in that situation. And moving on to the wonderful world of privacy. The privacy charts themselves haven't been changed since the last webinar, so I'm going to go through these quickly because I want to get to some of the more exciting stuff at the very end, which deals with AI. So keep in mind, these are the topics that are going to be, the laws that are going to be going into effect over the next 6 months or so. Of course, you are able to access this recording after the fact to get the more specific information. Again, hasn't changed since the last one. So keep in mind, all of these have thresholds under which they're not applicable typically. So Minnesota, 100,000 consumers or over 25,000 of gross revenue, or at least 25,000 Minnesota consumers. Maryland, again, nothing's changed. So these are the ones going to affect over the next 6 months. I do also want to talk about some of the I'm going to skip this slide because we have talked about this. Nothing's changed on this slide either from the last webinar. I want to talk about this slide. So this is where they're kind of differ. So generally privacy laws tend to be very similar. They tend to have the similar data level exemptions and entity level exemptions where that's where typically you may not have to comply. So employee level data tends to be exempted because you have to follow strict practices with relation to employee level data. Same thing with HIPAA, you're already subject to HIPAA. Fair Credit Reporting Act data tends to be exempted because the FCRA is very stringent with data handling practices. This is where some of the laws tend to deviate from each other and have differences. So for example, in Minnesota, controllers must have consent to process sensitive data. So for example, sensitive data includes data revealing racial or ethnic origin, religious beliefs, mental or physical health diagnosis, sexual orientation, citizenship, immigration status, data collected from a known child or specific geolocation data. Minnesota is also very focused on automated profiling and artificial intelligence. I believe I'm talking about Minnesota and AI a little bit later in this presentation, but there's some states that are getting very, very focused on AI. So that would be one of the differences where Minnesota is kind of deviating from some of the other privacy laws, which tend to be pretty similar. So note that in Maryland, controllers are also prohibited from selling sensitive data, which includes data that reveals information such as racial or ethnic origin, religious beliefs, health data, sexual information, national origin, or citizenship. Kentucky requires a consumer to opt into the processing of his or her sensitive data. It's also important to note that Kentucky defines the sale of personal data as monetary consideration only, which differs from other US privacy laws. Usually privacy laws don't restrict it to monetary consideration only and consider it as receiving some other sort of benefit. So that's definitely a deviation from the other ones. Rhode Island requires affirmative opt-in consent in order to collect or process sensitive data. Its law has two unique features. First, entities that are subject to Rhode Island's privacy law are not required to honor universal opt-out mechanisms. And second, the law does not offer a cure period. So if you violate the law, you're going to be fined without a chance to fix it. So I know that we were talking about Washington in terms of the salary transparency and pay transparency laws, but you note that there was a cure period where they had 5 days to fix it. Rhode Island, there is no cure period here, so you don't have a chance to fix it. You're going to be fined without a chance to fix it. Indiana, there's a right to appeal any business denial of a data privacy right request. So if you get a data privacy request and you say, we don't have to answer this, we have an exception, that individual can appeal any data privacy request denial. So keep that in mind as well. We highly recommend reviewing any of these laws. Again, I reviewed this last webinar back in January, and there really wasn't much of an update on the slide, so I wanted to spend time on the other couple of items that we're going to talk about, drug screening and the bonus compliance topic. So if you have any questions specific about privacy, please feel free to throw those questions in there. Okay, so as we move into our discussion of drug screening, let's start with cannabis. Texas has already allowed the use of low THC medical marijuana to treat certain health conditions. As of September 1st of this year, the program is going to expand the number of qualifying medical conditions. So it's going to include the various conditions that you see here, as well as some other miscellaneous ones. It's going to include increased THC limits. It's also going to authorize more dispensaries and permit new product types, such as lotions and patches. Note that smoking cannabis is still prohibited. What does this mean for Texas employers, though? It does not provide employment protections, but there are still some considerations. Employers are able to establish and maintain drug-free workplace policies and can conduct drug tests. They can also prohibit cannabis use and impairment while on the job. Employers also might still be concerned about accommodation requests. While the Americans with Disabilities Act, or ADA, does not recognize cannabis use as a valid accommodation, the underlying medical condition itself for which the medical cannabis is used for treatment, that condition itself may be covered under ADA. So when it comes to accommodation requests and Texas medical marijuana use, it's best to consult with your legal counsel. Cannabis continues to make its way through the courts. I wanted to go over a couple of cases to kind of illustrate this. Under Tyler v. Penske, the plaintiff was a job applicant who had a Pennsylvania medical marijuana card for treating anxiety. He disclosed his card after receiving a conditional job offer. Allegedly, he was told by a recruiter that the company doesn't like medical marijuana cards. The employer rescinded the offer, telling him it was unable to accommodate his medical marijuana use. The plaintiff said he offered to stop using marijuana and seek alternative treatments, but the employer did not reconsider. The plaintiff sued under ADA for discrimination, retaliation, and failure to accommodate, the Pennsylvania Medical Marijuana Act, or MMA, and common law wrongful discharge. The employer moved to dismiss, arguing that the plaintiff was required to drive for the position and that the company as a whole was DOT regulated and subject to federal law where cannabis is illegal. Because it was a motion to dismiss, the court is required to accept plaintiff's factual allegations as true and deny the employer's motion to dismiss. The case will continue forward to review ADA claims, including whether the employer should have engaged in an interactive process after the plaintiff offered to find alternative treatment. Additionally, there's going to be a question of whether the DOT regulations preempted the Pennsylvania Medical Marijuana Act if the plaintiff's position did not require driving and was not subject to DOT. So more to come on that one. Just wanted to put that on your radar. That's the first case I wanted to talk about. Also just reviewed a case where the question of federal law applying is up in the air as the case moves forward. In this case out of Minnesota, the court found that federal law preempted state law, which shows that each situation is very fact specific. It also shows why interactive processes are very, very important. In this case, an employer worked in a safety sensitive position for an employer who's regulated by the DOT due to transporting hazardous materials. DOT regulations require random drug testing for employees who are in safety sensitive positions. The employee in this case tested positive for THC, which is the active ingredient in cannabis, after taking a random drug test, and he was discharged from his position. The employee and his union filed a grievance, but the discharge was upheld. The arbitrator did not address whether the employee was in a safety sensitive role under Minnesota's Drug and Alcohol Testing in the Workplace Act, or DATWA. The employee sued, alleging various violations of DATWA, which we will not get into here today. The court ruled that the federal level DOT regulations preempt the state level DATWA protections because complying with both would be impossible or would interfere with DOT drug testing procedures. This ruling is important because it shows that where state law conflicts with federal law, employers regulated by federal law must ensure compliance with federal regulations. I want to finish up the drug screening section of the webinar by talking about a different type of controlled substance. New Mexico joined Oregon and Colorado, becoming the third state to legalize the therapeutic use of psilocybin, or magic mushrooms. This psychedelic drug can be used to treat mental health conditions such as post-traumatic stress disorder, major depression, end-of-life care, and others. Like in Colorado and Oregon, it must be administered in state-regulated facilities. The program itself is to be implemented by December 31st, 2027. Interestingly, like cannabis, psilocybin is also a Schedule I controlled substance on the federal level. If more states legalize psychedelic mushrooms for medical purposes, as happened with cannabis for medical purposes, it'll be interesting to see if psilocybin runs into the same obstacles. Could a new trend be starting? Maybe not, but I'm sure people thought that with marijuana as well. So we'll see what happens. And now we're at bonus compliance topics. Oregon signed into law HB 3187 on May 22nd, and it goes into effect around the same date in August, so coming up here shortly. So very soon, employers and employment agencies cannot ask for the following age-related information unless an initial interview has occurred or the employer has extended a conditional job offer. This includes applicants' age, date of birth, and graduation or attendance dates from educational institutions. Employers at this point should review application materials, any screening tools, including any artificial intelligence, and interview workflows. This law also removed age limits for apprenticeships. Previously, apprenticeships were able to reject apprenticeship applicants who had not finished the program until after they turned 7 years old. That provision has now been revoked. So make sure that you're reviewing any applications, any AI-related tools to make sure that they are fully in compliance before this comes up in August, assuming that you are impacted by Oregon laws. Spokane, Washington recently amended its local fair chance hiring ordinance, addressing discrimination against unhoused individuals who seek employment. Private employers operating within Spokane are prohibited from discriminating against applicants who are homeless, which also includes those living in shelters, on the street, or in temporary housing. Employers cannot ask for an applicant's housing status, including address or residence history, on job applicants or orally or in writing during interviews. Employers are allowed to ask for mailing address or preferred method of contact. Housing status can only be considered if it has a bona fide and legitimate relationship to the job's primary duty. The changes went into effect on May 25th, so employers should review their policies and workflows as soon as possible if they're not already in compliance. And we are going to be moving on to some artificial intelligence discussion. On June 25th, 2025, the California Civil Rights Council approved several changes to regulations issued under the California Fair Employment and Housing Act, or FEHA. Effective on October 1st of this year, the regulations clarify how existing anti-discrimination laws apply to the use of AI and automatic decision systems, or ADS, in employment decisions. The goal is to prevent bias and discrimination in employment. The updated regulations include expanded definitions. A broad definition of automated decision system has been added. ADS is defined as a computational process making decisions or facilitating human decision-making regarding employment benefits. Several examples of types of tasks are included, including tools that can screen resumes or applications, rank or score candidates, analyze facial expressions, voice, or behavior in interviews, make predictive assessments about an applicant or employee, measure skills, target job ads or other recruiting materials to specific groups, use games, puzzles, or assessments to evaluate traits like personality or aptitude. They also added a new definition for agent. This is defined as any person acting on behalf of an employer, directly or indirectly, to exercise a function traditionally exercised by the employer or any other FEHA-regulated activity. Mouthful definitions. This includes recruiting, screening, hiring, promoting, or making any other employment-related decisions. It's also important to note that any agent of an employer is also an employer for purposes of FEHA. The updated regulations also cover pre-employment and hiring practices under FEHA. FEHA already included provisions related to pre-employment practices. Now, pre-employment practices must expressly cover those practices conducted using an ADS. As an example, an employer must make sure the ADS does not cause a disadvantage to someone with a disability, perhaps requiring the employer to provide alternative formats. The updated FEHA regulations also reinforce California's Fair Chance Act. So in other words, employers cannot use an ADS to inquire into or obtain information about an applicant's criminal history prior to extending a conditional job offer. The updated regulations also update substantive provisions on discriminations. Employers cannot use an ADS or selection criteria that results in discrimination based on any protected characteristics, for example, race or gender, among others. This also includes indirect discrimination through proxies. For example, the use of a zip code in an ADS can create an indirect bias if a certain race tends to be populated in certain zip codes. It's important to point out that employers are now directly responsible for the actions of their agents, including recruiters, staffing firms, and other third-party vendors when they use AI tools on their behalf. This applies even if the vendors are independent from the employer. Under the updated regulations, an employer might be able to show that it has made certain anti-bias efforts in order to show that as a defense to legal claims. Finally, there's been an update to record requirements. Employers have to keep records of any ADS data or data generated using AI, and they have to preserve them for at least 4 years. It used to be 2 years, so the requirement has doubled to 4 years. Colorado also has some AI updates. This law, the Colorado Artificial Intelligence Act, will go into effect on February 1st, 2026. Under this law, developers and implementers of certain high-risk AI systems must protect Colorado consumers from risks of algorithmic discrimination. They do not make these words easy to say, I swear. They must also disclose that consumers are interacting with an AI system. A high-risk AI system is one that infers outputs based on data that is input, and that AI system has a material, legal, or similar effect on what is being provided to the consumer. For our purposes here, high risk includes employment-related decisions. It's important to note that the employer itself does not need to be located in Colorado. Consumers have the right to opt out of AI-based decision-making. They can also appeal AI-based decisions and request human review. Deployers of AI systems must disclose when a high-risk AI system is used in a decision that results in an adverse outcome for the consumer. As with privacy laws in general, including those specific to AI, there are some exemptions. Entities that operate under other regulations may be exempt, although there can be some caveats. Entities using certain approved technologies may find that those technologies can also be exempt. Small businesses with less than 50 employees that do not train AI with their own data can also be exempt. Colorado is expected to issue further guidance as well as refine the law before its effective date. So hopefully by the next time we have another webinar, we should have some further information on that. Illinois also has an amendment that will be effective in early 2026. This amendment will prohibit employers from using AI that subjects employees to discrimination on the basis of protected class, also including bias. Employers are required to notify both employees and applicants when using AI during all stages of the employment lifecycle. So in order to be able to effectively do this, employers have to understand how AI is actually used in its employment decision. For example, do they use resume scanners and chatbots? And they have to be able to explain in an easy to way understand to their employees and applicants. So what can we expect as we head into 2026 in the next 6 months or so? We may not see new Fair Chance Act legislation immediately, but it's clear that this type of law is only going to expand. It's definitely not going away. Because of the complexity of some of these laws with either specific forms, individualized assessments, or set waiting periods, employers should be ready to review carefully. Pay transparency is continuing, and employers who have multi-state footprints should be especially aware. We have numerous privacy laws coming into effect. Sorry that I didn't have enough time to review them more specifically, but I mean, they're out there. They're very similar. Recommend spending some time to review them if you haven't already. There's surely going to be others on the horizon, maybe a federal privacy law sometime in the future. There haven't been as many marijuana laws recently, but there definitely have been cases winding their way through courts. Use of AI, especially in automated decision-making, is becoming a very important topic in employment and in background screening. We talk about it at industry conferences all the time and the different webinars that industry leaders talk about. So that's becoming a hot topic. The White House also very recently released its strategic plan on AI. I didn't really cover it because it just came out about a week ago, but should hopefully be talking about it by the next webinar at the latest. So more to come on that. Stay tuned to future webinars. Any posts for more information, definitely keep you posted. Before we take questions, we'd like to recommend some best practices. First, always work with your counsel, whether in-house or outside counsel. I tend to speak in generalities in webinars, but these laws can have nuances and exceptions. Your counsel can give you advice specific to your situation. Review your background and drug screening programs to confirm you're still complying as laws change. We recommend viewing at least annually, but also as new laws pop up. Update your employment applications and hiring processes to meet any new Fair Chance Act requirements. If you're subject to pay transparency laws, determine if your materials need to be updated. Determine how new privacy laws impact your organization. Be aware of any new legislation and case law regarding drug screening. As we saw today, while there's major categories in screening that tend to come up more often, there's also a lot of miscellaneous areas that impact your screening program. So thank you so much for joining me today. We're now at the end of the major part of the presentation, and with the time that we have left, we're going to have some questions.
Thank you, Jennifer. The first question that we have is, what is best practice on providing pay ranges to applicants for states such as Connecticut that don't require it in the job posting, but prior to the offer?
So if you need to provide it prior to the offer and just to a specific person, I would imagine that you could provide it just to that specific person. rather than post it in the job and like the posting. I would need to look at that very specifically. Let me follow up with you specifically rather than answer off the top of my head. And I probably just covered that, and I apologize. I know I covered a bunch of pay transparency laws, but let me follow up with you specifically on that so I can look at it specifically.
Fantastic. The next question is with the pay transparency law in New Jersey, is there any direction for employers based on in New Jersey or based on neighboring states but work in New Jersey?
So that's where it gets complicated, because when you have neighboring states, I mean, people potentially could be living in a neighboring state but applying for positions in New Jersey. I've seen where companies will post like a wider pay range, and especially for remote positions where they might list and provide like call outs for certain jurisdictions. Like they say that like certain pay ranges might apply to certain geographical areas. So something like that could potentially apply to your organization. It's hard too, because I'm sure with being so close to New York, especially New York City, it's got to be difficult for posting pay ranges for New Jersey specifically, because I'm sure you have out-of-state applicants. If that person, if you want to provide that information to me, Danielle, I could work with that person as well.
I will do. The next question that we have is, when a state law references employee count thresholds, is that based on the number of employees working in that specific state, or is it based on the company's total number of employees nationwide?
It really depends on how the statute is written. It depends on how the statute is written. Sometimes it's based on the number of employees working within that specific city or state. Sometimes it's total number of employees for the company nationwide. It's very specific to how that law is written, unfortunately. That's what makes it so interesting.
Yeah, definitely. Very interesting. All right, so this will be the last question that we have. The question is there language that we need to use if AI is being used on job descriptions?
It probably depends on the state and to how in depth they want you to go, because certain states that we just discussed said that they want disclosure if AI is being used anywhere in the employment process, the employment workflow. But I don't necessarily know if there's any specific language. It would really involve diving into the law itself to see if there's any specific language. Yeah, unfortunately, my answers right now tend to be, you have to look in the law. And I apologize for that. A lot of these laws are just very specific, and you have to go into the law to see if it says you have to provide information or if it says you have to specifically state this specific language. Yeah, if you want to provide that information to me as well, I can look at that.
I will definitely do. Thank you, Jennifer, for facilitating this informative webinar, and a special thank you to our attendees for joining us today. If you have any additional questions, please contact us at marketing@AccuSourceHR.com. On behalf of the AccuSource HR team, we wish you all an enjoyable day.